In this edition of Critical Compliance, we look at recent trends in False Claims Act enforcement activity by the Department of Justice. The FCA is a potent civil enforcement statute that needs to be on the radar of all companies that do business, directly or indirectly, with any U.S. government agency. Among other things, the FCA prohibits knowingly causing false material information to be included in any claim made for payment from the U.S. government, or made to avoid or decrease an obligation to pay the government. In investigating a potential FCA claim, the DOJ has broad authority to compel documents and testimony to investigate whistleblower or qui tam allegations in order to decide whether to intervene to bring its own lawsuit. DOJ can also initiate its own investigation, for example, based on a fraud referral from another agency or a state. Where there is a liability finding, the government may recover treble damages and significant penalties. The DOJ recently announced that fiscal year 2023 saw a record 1,200 plus new FCA matters initiated, over a 25% increase from the prior year. That number includes 500 matters that the DOJ itself directly initiated, as opposed to matters that originated via qui tam suits, also a record. According to the DOJ, fiscal year 2023 saw $2.7 billion in total FCA judgments and settlements. While healthcare and life sciences cases accounted, as usual, for the majority of recoveries, of note, last year's recoveries related to defense contracting increased to over $500 million. These cases can involve allegations of procurement fraud and submission of inaccurate information related to, among other things, product specifications and compliance with contractual, statutory, and regulatory provisions. Next, resolution of customs cases doubled year over year. These matters typically involve allegations of duties undervaluation, misclassification of goods under the harmonized tariff schedule, and misidentification of country of origin on submissions made to the Department of Homeland Security. This trend towards increased FCA enforcement shows no signs of slowing down. Now more than ever, it's pivotal that companies, particularly in industries receiving greater attention, have a handle on their potential FCA risks. That means having a clear understanding of what information is being, or may potentially be, submitted to the U.S. and its agencies in the course of business, including by third parties and agents. For more information on FCA compliance practices and other compliance topics, visit arnoldporter.com and stay tuned for more in our Critical Compliance series.